Hello, everyone, and welcome to Dorsey and Whitney's M&A Update webinar. I'd like to introduce Brian Burke, a partner in Dorsey's Mergers and Acquisitions Group. Brian?
Thanks, Rima. Good afternoon, everyone, and welcome to the January 2025 edition of the M&A Update, our annual review of Delaware corporate and alternative M&A law developments that every M&A practitioner needs to know. My name is Brian Burke, and as always, I am joined today by my colleagues Amelia Messa out of our Delaware office and John Van Horn from our Minneapolis office. In the next hour, we will cover quite a bit of ground, looking at the latest updates on controlling stockholder transactions, non-reliance provisions, non-competition agreements, drafting lessons for disclosure schedules, and much, much more. But first, we start, as we always do, with the news from Delaware, and I turn it over to you, Amelia, to lead us off.
All right, thanks, Brian. So in our news from Delaware, we have some updates to our courts. Vice Chancellor Glasscock actually retired this year, effective as of a couple of weeks ago. He had been on our court since 2011, so we wish him well. We now have a new Vice Chancellor, though. We have Vice Chancellor Bonnie David. She was confirmed in December by our Delaware Senate. Before that, she was a magistrate in Chancery, so she's got great experience, and she actually started her career as a clerk for Vice Chancellor Glasscock. So we look forward to reading her decisions. Our Chancery Court, for anybody who's been there recently, knows that things are kind of slowing. They have such a heavy caseload. It's been an issue for a number of years. A couple of years ago, the state actually funded 2 new vice chancellors to try and help things out, but we are still having issues. So this year, the state of Delaware has funded 2 new magistrates in Chancery. So we have the Honorable Christian Douglas Wright and the Honorable Danielle Gibbs. So hopefully that brings some relief to our courts. And it wouldn't be an M&A update these days without discussion of Elon Musk. He has basically spent the better part of this year being a bit bitter with the state of Delaware, mainly due to a certain Chancery Court case, which will be discussed later, where he kind of blames Delaware for the loss of billions of dollars. After that, he very vocally said he was taking all of his entities out of the state of Delaware. He moved them to Nevada and Texas. He did urge others to do the same. I have yet to see any of our clients move, and I haven't heard of others following him. So we'll see if anything changes there. And then after the election, he actually tweeted, or whatever it's called these days, when there are egregiously wrong legal judgments in a single state that substantially harm American citizens in all other 49 states, the federal government should take immediate corrective action. So I think it's pretty clear he's talking about Delaware here. And he's basically started pushing for the idea of a federal corporate law. Obviously, with my own job security in mind, I find this to be incredibly interesting. And I think it raises a number of questions. First of all, could our Congress actually do this? Could they agree upon it? Would they just take Delaware's statute? That's what some other states do. Would they be able to update it every year? Would it apply to alternative entities as well? So lots of questions there. How would federal judges handle interpreting it? Would it be the same throughout the country? Notably, if someone like Musk got a decision they weren't happy with, they couldn't just go to another state. They're kind of stuck with the federal law. And then, of course, how much influence is Elon Musk actually going to have? So we'll kind of wait and see what happens with the new administration. So just like every year, Delaware's entity statutes were all updated to stay current with case law and then things that practitioners are seeing. They all went into effect, as they do every year, on August 1st. So to start us off with our alternative entity amendments, there weren't a ton of big, exciting amendments this year. With respect to the alternative entity statutes, I think the biggest one has to do with certificates of merger. Before this year, you were allowed in a certificate of merger to amend the surviving entity's name and registered agent and office, but that was it. Now with the new amendments, you are allowed in your certificate of merger to amend your survivor's certificate of formation or limited partnership for any purpose. Where I think this is going to come in the most is when you're dealing with a merger with a limited partnership. You're required for a limited partnership to list the general partner in the certificate of limited partnership. So if you're changing your GP when you do the merger, now you can just do that in the certificate of a merger and you don't have to do a second filing afterwards. Certificates of merger also can now amend and restate formation filings, and all of this is consistent with the DGCL. We also had amendments with respect to revocation of dissolution. So if you're dealing with an LLC or a partnership and you have like an oops moment and you accidentally dissolve your entity, there are ways that you can bring it back to life. It basically requires revocation of dissolution, which is the same vote or consent that was needed to dissolve or terminate your entity. The amendments here clarify the wording with respect to that vote. The vote is only going to look at what's in the partnership agreement or LLC agreement, not to outside documentation. So this would be like if you had a loan document that required lender consent to dissolve, that would not factor in for your vote with respect to revocation. This year, we did have amendments to our statutory trust act. That act is actually only amended every other year, so this was an on year. We did the same types of amendments with respect to certificates of merger being able to amend a certificate of trust. There were also amendments with respect to how a DST can vote securities that it holds. Now, beneficial owners of the Delaware Statutory Trust can direct the trustee as to how to vote. And then the trustee, should they follow the direction that was given to them, they're not going to have any duties or liabilities, assuming they exercise the standard of care that's set forth in their trust agreement. Finally, we had amendments with respect to conversions of Delaware statutory trusts. So here, if you file a certificate of conversion that has a later effective date, you actually don't have to have the approval for your trust agreement or certificate or the conversion generally until that actual effective date, not when the certificate of conversion is filed. So this was similar to amendments that we did last year with our other statutes. And with that, I will turn it over to John to talk about our DGCL amendments.
All right, thanks, Amelia, and thank you all for joining us. I would say the 2024 amendments to the DGCL are a little more substantive and a little less technical than they've been in recent years. And the most significant amendments were driven by recent developments in Delaware case law. Starting with the amendments to Section 122, these were precipitated by the West Palm Beach firefighters versus Moelis case. The Moelis case invalidated as impermissible constraints on the board's authority to manage the corporation's affairs some provisions very commonly included in stockholders' agreements, including the right to designate directors, rights of pre-approval or consent over certain corporate actions. In its opinion, the court noted the tension between its decision and practices routinely employed by sophisticated corporate actors and observed the expansive use of stockholders' agreements suggests that greater statutory guidance may be beneficial. The Delaware legislature, being very quick on the uptake, responded with legislation that resulted in new subsection 18 in less than a month after the Moelis decision. New subsection 18 to section 122 expressly permits a corporation to enter into agreements with its stockholders, restricting the corporation from taking enumerated actions, granting to stockholders consent rights over certain corporate actions, and restricting the board from taking certain corporate actions. Under subsection 18, a stockholder agreement must be construed in a manner consistent with the corporation's charter and the DGCL. And finally, the new subsection does not relieve directors, officers, or stockholders from fiduciary duties implicated by the entry into or the performance of a stockholders agreement. In February 2024, the Court of Chancery declined to dismiss a challenge to Microsoft's acquisition of the publicly traded video game developer Activision Blizzard, based on some claims that certain common market practices utilized by the Activision board in approving the merger agreement violated certain provisions of the DGCL. The final approval board meeting is a milestone event in any public company deal. At its final approval meeting, the Activision board approved the then current draft of the merger agreement. As is often the case, the draft merger agreement presented at the meeting did not yet include the disclosure schedules or the surviving company charter to be attached to the merger agreement. The draft merger agreement also did not include the price per share to be paid in the merger or the names of the parties. Both party names and the price per share are often added just before signing an announcement for confidentiality reasons. As with Moelis, in its opinion, the court acknowledged that its holding did not square with norms of market practice, but nonetheless concluded that where market practice exceeds the generous bounds of private ordering afforded by the DGCL, then market practice needs to check itself. Well then, enacted in response to this decision, or scolding, whatever you want to call it, new section 147 provides that a board may validly approve an agreement as long as the agreement is in final or substantially final form. The legislative synopsis accompanying the amendment elaborates that section 147 is intended to permit board approval if, at the time of board approval, all of the material terms are either set forth in the agreement or are determinable through other information or materials presented to or known by the board. Section 147 also permits a post-approval ratification of any agreement, instrument, or document that is required to be filed with the Secretary of State, so long as the ratification occurs before the filing. New section 268A eliminates the requirement that the merger agreement contain the surviving corporation's charter for cash deals or other deals in which the merger consideration does not include the surviving corporation's any surviving corporation stock. Finally, new section 268B provides that for the purposes of the DGCL and its various approval requirements, disclosure schedules are not deemed to be part of a merger agreement. If you remember, last year, we reported on the Crispo versus Musk case, one of several litigation matters related to the acquisition of the social media platform formerly known as Twitter. In resolving a mootness fee petition submitted by a plaintiff in an earlier Twitter case, Chancellor McCormick created quite a stir in Delaware and among the M&A bar by suggesting that under Delaware law, a public M&A target left at the altar might not have standing to recover lost premium damages sustained as a result of a buyer who breaches the merger agreement and walks away from the deal. The possibility of being held liable for the deal premium lost by stockholders as a result of buyer's breach is widely viewed as providing a meaningful incentive for buyers to fulfill their contractual commitments under the merger agreement. The thinking here is that without fear of liability for lost premium damages, which can be substantial, the merger agreement merely represents an option for the buyer to complete the deal, with liability for the target's direct damages, which are likely to be insubstantial when compared to the lost premium damages, being the only consequence of the buyer's breach. As with Moelis and Activision, the legislative reaction to Crispo was swift. New section 261A1 confirms that parties to a merger agreement may contractually specify penalties in the event of a party's breach. The new statutory language specifically identifies lost premium damages as among the penalties that may be specified. In addition, new section 261A2 resolves some ambiguity created by the Crispo decision around the authority of representatives appointed in the merger agreement to represent the target company's stockholders. It does so by confirming that a merger agreement may expressly appoint one or more persons to serve as the representative of the stockholders of any party to the merger and delegate to the appointed representative the exclusive authority to enforce the rights of such stockholders. All right, I'll turn it back to you, Brian, for a review of developments in the law of controlling stockholders.
Great, thanks, John. Yeah, the first case law development we're going to talk about today is in the land of controlling stockholders and the question of whether a transaction between a controlled corporation and its controlling stockholder is entirely fair. So this line of cases was front of stage in January when the court reviewed Elon Musk's pay package and asked itself, And the first sentence of his 200-page post-trial opinion was the richest man in the world overpaid. But first, before we get to the case itself, a refresher on controlling stockholder transactions and entire fairness. So in Delaware, transactions between the controller and the corporation, or between the controller and non-controlling stockholders, when challenged, are governed by the entire fairness standard of review. It applies not just to direct transactions with controllers, but also whenever a controller extracts a non-ratable or unique benefit not shared with other stockholders. Now, entire fairness is the most exacting standard of review, and it requires the controlling stockholder to prove both substantive fairness, fair price, and procedural fairness, fair dealing. Furthermore, the burden of proof for both of those is on the controlling stockholder. If the transaction itself is not entirely fair, the court may order an injunction or even restitutionary recovery. Now, under the traditional Lynch doctrine, an independent negotiation structure may shift the burden of proof, such as through use of a negotiation by a special committee of disinterested directors, or through approval by a majority of the minority stockholders. But regardless of whether the defendant or the plaintiff bears the burden of proof, if entire fairness is the standard, cases are almost never susceptible to summary dismissal, as there are almost always questions of fact for trial. This is not to say that entire fairness is a death sentence. We have seen cases over the years where controllers have proved transactions are entirely fair, but it is to say that it is often a costly and expensive process to get to that point. But before we do, we must first determine if there is a controlling stockholder. For that, we look to the two-pronged test under Kahn versus Lynch communication systems, where a stockholder is found to be a controlling stockholder if he, she, or it owns more than 50% of the voting power of the corporation or exercises actual domination and control over the business and affairs of the corporation. Now, this latter prong is a facts and circumstances inquiry. It's not enough to show that the stockholder could theoretically have exercised control. They must have exercised actual control with respect to the specific transaction in question. Now, there's no bright line on whether Delaware courts will find control. It truly is a facts and circumstances analysis. Over the years in these M&A updates, we've reviewed cases where Delaware courts have found control where an individual stockholder or group held as little as 17.3% of the corporation. And we've also seen cases where they found no control, where the controller has held as much as 46% of a corporation. It really depends on the facts of the transaction at issue. So with that background on controlling stockholders and entire fairness, let's turn to Elon Musk. Now, Elon Musk has spent quite a lot of time in Delaware courts over the past few years. After 5 years of litigation, the Delaware Supreme Court agreed with Musk that Tesla's acquisition of SolarCity was entirely fair, even though Musk was a controller of both corporations. We're also familiar with the Twitter saga. We're on the eve of trial, which will likely have forced him to close on his acquisition of Twitter. Musk capitulated and closed the transaction. And that brings us to this latest case, where in a post-trial decision, Chancellor McCormick answered the semi-rhetorical question, was the richest man in the world overpaid? So plaintiff's claim here was that Tesla's directors breached their fiduciary duties by awarding Musk a massive performance-based equity compensation plan worth up to $55.8 billion. And furthermore, they argued that such a transaction was a conflicted controller transaction subject to the entire fairness standard of review. So what led to these claims? Well, in 2018, Tesla awarded Musk a performance-based equity plan, where Musk had the opportunity to secure 12 total tranches of options, with each tranche representing 1% of Tesla's outstanding shares based on certain vesting criteria. Now, importantly, this vesting criteria was quite ambitious. At the time, Tesla's market capitalization was a mere $50 billion. And in addition to having to meet revenue and EBITDA targets, it would have to climb to over $650 billion before all of the tranches vested. At the time, these milestones were viewed as difficult and ambitious to achieve. In hindsight, of course, just 3 years later, Tesla had a market cap of over $1 trillion. So now let's look at the parties involved in awarding this grant. So first, we of course have Elon Musk. Now, contrary to popular belief, Elon is not actually the founder of Tesla, but he did lead the company's Series A round back in 2004, has served as chairman of the board from 2004 through 2018, CEO since 2008, and at the time in 2018, he held a 21.9% equity stake in the company. For all rights and purposes, he was viewed as kind of the de facto founder of the company. The compensation committee tasked with evaluating this grant was comprised of many individuals that were friendly to Elon. For example, the compensation committee chair, Ira Ehrenpreis, had known the Musk brothers for over 15 years. He acknowledged his personal and professional relationship with the Musk brothers, had a significant influence on his professional career, and was a very close friend of Elon's brother Kimball, even attending his wedding in Spain. Brad Buss and Robin Denholm, also on the committee, received significant life-changing amounts of money from Musk-controlled companies. Robin had received over $280 million through sales in 2021 and 2022 of just some of the Tesla options she had received as part of her director compensation. And Antonio Gracias was a close friend of Musk who invested hundreds of millions of dollars in the Musk companies and had even spent Christmas with the Musk family. He was very close with Elon's mom and sister. Of the other directors, only 2 were actually involved in board meetings and votes on the 2018 grant. James Murdoch, CEO of 21st Century Fox, another close friend of Musk, and Linda Johnson Rice, who was a close friend of Antonio Gracias. Elon's brother Kimball was also on the board at the time, but he recused himself during discussions and votes on the grant. And there was a 9th board member who, for other reasons, was absent during the relevant period. Now, one other pretty important player here is Mr. Todd Maron, who served as the general counsel of Tesla. Todd was Elon's former divorce attorney, and his admiration for Musk literally moved him to tears during his deposition in this case. Whether that was a strategy adopted in his years spent navigating contentious divorces is hard to say, but in his new role, he was largely responsible for coordinating the board's review and approval process of the award and drafting the proxy statement. Now, the timeline here clearly showed Musk's influence on the process. In fact, it was Musk in April of 2017 who called his friend and compensation committee chair Ira Ehrenpreis to suggest the terms of a new equity incentive plan for himself. At the same time, in an earnings call just the next month in May of 2017, Musk said that he would be involved with Tesla for life and had no intention of stepping down. Now, throughout the remainder of 2017, Musk pushed the process with respect to his equity award. And ultimately, in January of 2018, on essentially the same terms initially proposed by Musk, the board approved the grant. 2 months later, the stockholders also approved the grant, despite both ISS and Glass Lewis recommending voting against the grant. Notably, the proxy here did not disclose the initial conversation where Musk proposed the terms of the grant to Ehrenpreis, and it described all of the directors involved in approving the grant as being independent of Musk. Following approval, Tesla admitted in a disclosure that several of the grant milestones were probable of achievement, and just over 3 years later, all milestones had been achieved. Now, the grant was challenged by one of the stockholders, and this proceeded to a 5-day trial in the Delaware Court of Chancery. The first questions the court asked was whether Elon Musk was a controlling stockholder, and Chancellor McCormick said clearly the answer was yes. Musk's relationship with the directors gave him enormous influence over Tesla. He was the paradigmatic superstar CEO with a nearly 22% equity stake, roles as CEO, chair, essentially the de facto founder, and he enjoyed thick ties with the directors tasked with negotiating his compensation plan. So at least as to this transaction, Musk controlled Tesla, and the defendants had to prove that the 2018 grant was entirely fair. So the second question the court asked was whether the burden of proof shifted from the defendants to the plaintiffs here, and Chancellor McCormick said no. As a reminder, the burden could have been shifted by implementing negotiation by a special committee of independent directors or by a fully informed vote of the majority and minority stockholders. But the board here is not independent, and although approval was conditioned on majority of the minority stockholder vote, the stockholder vote was not fully informed as the proxy statement inaccurately described the independence of the directors. The burden therefore remained on the defendants to prove that the 2018 grant was entirely fair. The defendants were thus left with the unenviable task of proving the fairness of the largest potential compensation plan in the history of the public markets. In looking at the 2 elements of entire fairness, the court first looked at procedural fairness, whether there was a fair process, and found the answer to be no. Musk had extensive ties with the people tasked with negotiating on Tesla's behalf. For example, he had a 15-year personal relationship with the compensation committee chair, Ira Ehrenpreis, who, in a moment of honesty in his deposition, testified that he did not view the negotiation as an adversarial process, but rather cooperative with Musk. The defendants here tried to point to concessions that they secured in the final plan and the number of meetings the committee held to consider the grants, but the court was not persuaded. It did not find the concessions meaningful, noted that the committee didn't use objective benchmarking data and looking at the award, and found that the number of meetings alone wasn't evidence of any substantive work on behalf of the committee. The court then looked at whether the price was fair, and again found the answer to be no. Defendants tried to argue that the plan was all upside for stockholders. By basing the vesting on increasing the market cap of Tesla, the full award would only be realized if Musk was able to increase Tesla's market capitalization from $50 billion to $650 billion, a clear win for stockholders. But the court said that this failed to ask the $55 billion question, which is, was the plan even necessary? Musk already owned 22% of the company, so his incentives were already aligned with the stockholders, and that he would stand to benefit significantly if the company increased in value. So was the plan even needed, or did a lesser plan have worked just as well? As a result, the court found that the grant was not entirely fair, and the court ordered rescission in its entirety. In the aftermath, some commentators were shocked at the outcome in Tornado versus Musk, none more so than Elon Musk himself, who Amelia noted has been vocal about his disdain for Delaware since then, moving all of his companies to either Nevada or Texas. Given all the publicity, the question has been whether other companies will follow suit. Both Texas and Nevada have been working hard at making their business laws friendly to new businesses. Texas revamped its courts, creating a new Texas business courts, which opened for cases on September 1st of last year. But as the dust settles, we've not seen anything close to a mass exodus of companies from Delaware. At least in the short term, nothing is likely to change Delaware's dominance. VC investors still insist on it, and it is still the most well-developed case law and experienced judiciary. Okay, Elon Musk's record in entire fairness trials in Delaware is now 1-1. He won the case challenging Tesla's acquisition of Solar City, but he lost the one regarding his pay package. If a controller wants to avoid all of that, if they want a basis for summary dismissal in an otherwise controller-conflicted transaction, then they can put the MFW conditions in place. The MFW conditions refer to those articulated in the 2014 Delaware Supreme Court case of Kahn versus MFW, which states that the business judgment rule, not entire fairness, governs review of a controlling stockholder freeze-out merger if, and only if, the controller conditions the transaction ab initio from the start on approval by both a well-functioning special committee of independent directors and approval by a majority of the disinterested stockholders, that is, majority of the minority stockholders. We saw later in SEPTA versus Volganow that the MFW safeguards can also be used in the sale of a business to a third party, where the controller is receiving different consideration than the other stockholders. But the Delaware Supreme Court's decision in Olenek versus Lozinski makes clear that these conditions have to be in place before any substantive economic negotiations have occurred. Now, if you do get the MFW conditions in place in time, a controlling stockholder can have the case dismissed on the pleadings, which we've seen time and time again. But all the requirements of MFW need to be followed, otherwise the transaction remains subject to entire fairness. We've seen cases along those lines as well. Now that all takes us to the latest case in the Match Group litigation, in which a unanimous Delaware Supreme Court answered the question, does a special committee need to be completely comprised of independent directors, or can it just be majority comprised of independent directors? So the transaction issue here was a reverse spinoff of Match Group, a controlled subsidiary of Interactive Corp. Through its ownership of Class V high vote common stock, Interactive Corp controlled 98.2% of the voting power of Match. After the transaction, minority stockholders of Match brought claims that the transaction was unfair, as IAC received multiple non-ratable benefits at the expense of minority stockholders. This case first went before the Chancery Court, where the defendants moved to dismiss, because they said they followed the MFW requirements, and therefore the standard of review should be the deferential business judgment rule. IAC had conditioned the deal from the outset on approval by a special committee of independent Match directors, and conditioned the deal on approval by a majority of uncoerced, fully informed, and unaffiliated Match stockholders. The Match board had appointed 3 people, Thomas McInerney, Pamela Saman, and Ann McDaniel, to a special separation committee that was fully empowered to retain its own advisors and negotiate, approve, or disapprove of any separation transaction. IAC proceeded to negotiate with the special committee, and ultimately the special committee negotiated for and approved a spinoff plan, which was subsequently approved by a majority of the minority stockholders. In the Chancery Court's decision, it reviewed the protections in place and granted the motion to dismiss. It found the company had followed both prongs of MFW and therefore shifted the standard of review to the deferential business judgment rule. Here, the transaction was negotiated and approved by a special committee of independent directors. Although the court found that one of the three directors, Thomas McInerney, was not independent, because the remaining 2 out of 3 were, the special committee itself was majority disinterested and fulfilled that prong. And the transaction was also approved by a majority of the minority stockholders in a fully informed, uncoerced vote. Importantly here, the stockholders were fully informed as to the potential conflicts that Thomas McInerney had. Now, on appeal to the Delaware Supreme Court, they reversed the Chancery Court's decision and found that the MFW requirements were not satisfied. The court said that the special committee must function as an independent negotiating body. In this case, because one of the 3 members of the committee was not independent, due to his close ties with the controller, including having served as its CFO and earning over $55 million from employment with IAC in the past, the court held that for MFW purposes to replicate arm's length bargaining, all special committee members must be independent of a controlling stockholder, not just a majority. Therefore, MFW was not satisfied. Entire fairness was the applicable standard of review. The motion to dismiss was denied. So, how useful is MFW? In the span of 3 months last year, the Delaware Supreme Court reversed the Chancery Court in 3 separate cases where the Chancery Court had dismissed claims based on MFW. Aside from this match case, the other dismissals were, at least in part, due to the special committee not properly disclosing their advisors' potential conflicts of interest in the proxy materials solicited in the stockholder vote. This all goes to show that while MFW can result in a dismissal on the pleadings, plaintiffs are still finding ways to challenge it, and controllers need to continually evaluate whether MFW and the uncertainty it brings is worth the trouble. Okay, enough on controlling stockholders. John, I will turn it over to you for an update on non-reliance provisions.
All right, thanks, Brian. We now return to a topic we've covered regularly in recent M&A updates: efforts by sellers to limit their liability for fraud in connection with M&A transactions. The cornerstone case here is Abry Partners from 2006. In the Abry Partners case, then Vice Chancellor Leo Strine held that extra contractual fraud, that is, fraud outside the contract, can be eliminated entirely by clear contractual language stating that the buyer has not relied on statements made outside of the contract. Liability for contractual fraud, that is, fraud as it relates to representations made within the contract itself, may be limited or eliminated for negligent or reckless misstatements, but can't be limited or eliminated for knowingly false statements. Multiple cases since Abry Partners have upheld the general proposition that a clear statement of non-reliance in the purchase agreement can effectively eliminate liability for extra contractual fraud, while also defining the outer limits of the Abry Partners doctrine. The latest case in the Abry Partners line is Labyrinth versus Urich from last year. The Labyrinth case serves as both a useful review of the elements of an effective disclaimer of reliance on statements made outside of the contract and adds a new perspective on some boilerplate language that many of us have encountered in drafting and reviewing M&A purchase agreements. Labyrinth involved a post-closing dispute between buyer and seller in which buyer alleged, among other matters, that seller made fraudulent statements outside the merger agreement about the target's business. Most of these statements related to the financial condition of the target and its collection practices. Buyer alleged reliance on these extra contractual statements, while the seller countered that any claims for contractual fraud were barred by anti-reliance language contained in the merger agreement. The opinion, authored by Vice Chancellor Zern, is a helpful summary of the multiple ways in which a seller attempting to shield itself from claims for extra contractual fraud can get it wrong. Lesson 1. The Labyrinth merger agreement included the integration clause shown here. Litigants in several post-Abry Partners cases have attempted to use the inclusion of a customary integration clause to limit their exposure to extra contractual fraud claims. Integration clauses define the bounds of the parties' contractual obligations to each other, but claims for extra contractual fraud are by definition tort claims and not contract claims, and the integration clause speaks only to matters of contract. As a result, a standard integration clause is not an effective disclaimer of reliance on statements made outside the contract. Lesson 2. The Labyrinth merger agreement also included what I refer to as a no other representations representation. This is a representation made by seller, and it generally says something to the effect that the representations and warranties of the seller contained in the agreement are the exclusive representations and warranties, and that neither seller nor any other party has made any other representation to buyer other than the representations and warranties included in the definitive agreement. That all sounds pretty good, doesn't it? This approach fails for 2 reasons. First, the no other representations representation is only a factual statement that no extra contractual representations were made. Remember, under Abry Partners, a clear statement of non-reliance is required to bar claims for extra contractual fraud. And Delaware courts since Abry Partners have consistently ruled that a no other representations representation on its own is not a clear statement of non-reliance sufficient to effectively bar liability for extra contractual fraud. Second, the representation is a statement made by the seller and not a statement by buyer. The post-Abry Partners cases have also consistently held that an effective disclaimer of reliance must be made in the voice of the buyer. So let's take a quick detour here to look at some purchase agreement language that was litigated in the 2015 Prairie Capital case. So, is this an affirmative statement by the buyer? Yes, it is. The first sentence is a buyer statement about its due diligence investigation of the target. The second sentence is buyer's statement, affirmative statement of reliance on its due diligence and on the representations and warranties of the seller contained within the purchase agreement. But does this affirmative statement, buyer statement, contain clear language disclaiming reliance on representations made outside the agreement? This is where things get a little harder for seller, in my opinion. This capitalized language doesn't exactly say that, at least not the way I read it. The first part of the capitalized language is basically the no other representations representation packaged up as a buyer statement of fact. The second part disclaims any additional representations, but it doesn't specifically say that buyer has not relied on outside representations. No variation of the word rely or reliance appears anywhere in this provision. Still, Vice Chancellor Laster, in deciding Prairie Capital, rejected a strict approach that would require any specific formulation, including a variation of the word rely, declaring that Delaware law does not require magic words. Tell me if you've heard that before. And he concluded that the language you see here is sufficiently powerful to serve as an effective disclaimer of reliance. Now, back to Labyrinth, and here comes the twist. At first glance, this language doesn't look that much different from the Prairie Capital language we just looked at. The seller in Labyrinth argued that this language, together with the no other representations representation and the integration clause, formed an effective statement of non-reliance. It is true that nowhere in here does it say buyer has not relied or buyer disclaims reliance, but remember Prairie Capital. There are no magic words in Delaware, right? In her opinion, Vice Chancellor Zern determined that the first sentence you see here can be read as an express representation by the buyer that it did rely on extra contractual information provided by the seller in connection with its independent investigation. From the opinion, buyer formed a judgment or opinion of the business, results of operation, prospects, condition, financial or otherwise, or assets of the company, that's from this language, from what seller provided, namely, again from this language, the personnel, properties, assets, premises, books and records, and other documents and data of seller and the company. The Vice Chancellor then turned to the second sentence, concluding it only identifies seller's representations, but it does not preclude buyer's reasonable reliance on representations that are not identified. So, analyzing this package of contractual provisions as a whole, Vice Chancellor Zern concluded that the merger agreement did not contain a clear statement of non-reliance sufficient to bar claims for extra contractual fraud. So, what can a sell-side drafter do to effectively protect the seller from claims of extra contractual fraud? First, while there may be no magic words in Delaware, there are words that have superpowers. In this context, those words are rely or reliance and disclaim. Delaware courts have now spent nearly 2 decades parsing various word salads to determine whether they are the equivalent to a simple statement that buyer has not relied on any extra contractual statements. I note here, while we talk a lot about Delaware in M&A update, other states have laws that are applied to M&A contracts too. And some of those states do require the express use of the words rely or reliance as part of an effective disclaimer of reliance. Second, regardless of the language used, trying to use a seller representation as a buyer disclaimer of reliance is a proven loser. The third point relates to the laundry list style of contract drafting. So I often see the statement of non-reliance coupled with an illustrative list of information or deal materials on which the buyer has not relied. This list often includes the confidential information memorandum or SIM, the management presentations, and financial projections or forecasts. I'm personally not convinced that the laundry list adds much if the rest of the drafting is on point, but it probably doesn't hurt either, and including the list may be helpful in framing the issue in deal negotiations. In terms of the independent investigation language, I think before Labyrinth, most practitioners were of the view that the independent investigation clause, like the one contained in the Labyrinth agreement, were helpful to sellers in establishing non-reliance. Given that the opinion cuts in the opposite direction, I kind of wonder if we'll see those clauses go a little bit to the wayside. That's something to keep an eye on as we go forward. Finally, in case you're left with the impression that this is something the buy side doesn't need to think about until or unless the issue is raised in deal negotiations, I present for your consideration Trifecta Multimedia versus WCG Clinical Services. This case involves a motion to dismiss claims by the seller that he was fraudulently induced into selling his healthcare technology company by several promises made by the buyer about the post-closing operations of the target business. These promises related to a contingent revenue-based earnout that ultimately was not achieved. None of the promises alleged to have been made by the buyer were included in the purchase agreement. In analyzing the seller's claims of fraudulent inducement, Vice Chancellor Laster engaged in a detailed and rather amusing breakdown of whether or not some of the alleged extra-contractual promises constituted non-actionable puffery under Delaware law. The Vice Chancellor characterized some of the buyer's alleged promises as classically vague statements that a commercial party routinely makes in deal-making courtship. But despite finding some of the alleged buyer statements to be puffery, Vice Chancellor Laster found other alleged statements to be specific enough to go beyond puffery. So, with the seller having sufficiently pled the existence of extra-contractual statements otherwise sufficient to sustain a claim for fraudulent inducement, the question then turned to whether or not the purchase agreement contained an explicit disclaimer of reliance in buyer's favor on extra-contractual statements. In a straightforward application of Abry Partners, the Vice Chancellor determined that the purchase agreement did not contain an effective disclaimer, rejecting buyer's claims that the integration clause included in the contract constituted a disclaimer of reliance. So, as we've discussed in many M&A updates, including this one now, I guess, earnouts are a privately ordered full employment act for deal litigators, or to borrow from the Vice Chancellor's courtship analogy and a callback to Brian's presentation, maybe they should be called M&A divorce lawyers. In planning for the possibility that the once happy courtship ends in divorce, buyers are well advised to consider dropping a well-drafted reliance disclaimer into any purchase agreement that includes earnout provisions.
Okay, Amelia, now on to non-competition agreements.
All right, so first of all, where do things stand with non-competes? As we predicted last year, in the spring, the FTC did create a nationwide rule that banned most non-competes from employment agreements. But then in August, we have a case out of Texas that enjoined the FTC from enforcing that ban. So we're going to have to just wait and see what happens there. In Delaware, we had definitely been seeing a huge increase in the number of non-compete cases. This is because people stopped putting them in their employment agreements, which would be governed by California law and other states which had public policy and other prohibitions on non-competes. So they were instead putting them into LLC agreements so that they would then be governed by Delaware law. Vice Chancellor Lanster, in particular, started commenting on this practice and really his dislike of it, both in case law and in other places, such as his LinkedIn page, where he provides his views on things, but makes it very clear that he is not speaking in his capacity as Vice Chancellor. It is worth a follow. So one of the things that he has been pushing for is legislative change in Delaware here, although so far we have not made any statutory amendments. This year we did have 2 Delaware Supreme Court cases on non-competes, which were interesting. The first one being Cantor Fitzgerald. This one was a couple of limited partners of Cantor Fitzgerald left. They went on to work for competitors. They were bound by Cantor Fitzgerald's partnership agreement, which had a provision that the court calls a forfeiture for competition provision. This is a little bit different than a typical non-compete. This one basically says that the partnership that otherwise owed these people money no longer had to pay it if they went on to work for competitors. So the Chancery Court looked at it. They held that those provisions in the partnership agreement were unenforceable because they were too broad and unreasonable. So they basically treated the forfeiture for non-competition provision just like any other restrictive covenant and subjected it to a reasonableness standard. Our Supreme Court weighs in and reversed. They looked at the provision more under the lens of contract, freedom of contract. They focused particularly on the fact that our Partnership Act says it is designed to give maximum effect to the principle of freedom of contract and to the enforceability of partnership agreements. So basically what you negotiate for, as long as there's no bad faith or unconscionability in the negotiation process, parties are going to be held to their contracts. They didn't think the reasonableness test that applies to other non-competes should apply here because forfeiture for competition provisions are different. They don't actually stop somebody from working, so it's not a restraint on trade. The other key thing here is that our Partnership Act actually permits limited partnership agreements to contain consequences for certain actions, which can include forfeiture. So for now, forfeiture for competition provisions are different and they are okay in Delaware. The second case was Sunder Energy. This one we talked about last year in the M&A update. The facts of this one, we had Tyler Jackson. He was a sales guy for Sunder Energy and sold solar panels. He left the company and went to work for a competitor, and he took some of his sales team members with him. He was subject to restrictive covenants in an LLC agreement. The interesting thing here was how that LLC agreement went into effect. The company for a number of years had been operating under an oral agreement, which, as we've said in the past, is a very bad idea. But here the founders all got together and they used company counsel to draft up a written LLC agreement. Then when all the employees were off at a New Year's Eve party, the founders sent them the agreement, told them it was urgent that they signed it. They assured them that the LLC agreement contained all the terms that they were used to. It had been drafted by company counsel, of course. And so our employees do what they were told. They signed it. They didn't read it first. They didn't have counsel look at it. and to their detriment. The LLC agreement, in fact, really just benefited the founders. It eliminated their fiduciary duties, took away voting rights for employees, and subjected them to restrictive covenants. The restrictive covenants here were so unreasonable that the Chancery Court found that in practice, they would have actually prevented the employees' children from selling Girl Scout cookies. So our Chancery Court looks at it, and first they find that the LLC agreement had not been validly adopted, mainly because the founders, with their New Year's Eve stunt, had breached their fiduciary duties of disclosure. Therefore, the restrictive covenants were not going to be enforceable. The court did look at the actual restrictive covenants themselves. They subjected them to the reasonableness standard and found that they were overly broad, unreasonable, and unenforceable. So our Supreme Court weighed in and they affirmed here. They agreed with the Chancery Court that the restrictive covenants were unreasonable. The interesting thing here is the Supreme Court has a really interesting discussion on blue penciling these types of provisions. So basically, they were asked to go back and rewrite the provisions to make them reasonable. The court refuses to do that here and refuses to adopt a bright line rule with respect to blue penciling. It doesn't go so far to say that it will never use it, but the parties must show that there was equal bargaining power, which there clearly was not here. They also didn't want to incentivize employers to craft these overly broad covenants that would then, the only consequence would be that somebody would dispute it and the court would make it reasonable. The court did reverse a small piece of the decision of the Chancery Court, really just to the extent that the opinion could be read to hold that the entire LLC agreement was unenforceable. But this was really just a procedural finding and it did not impact the findings with respect to the restrictive covenants. So with that, I'll turn it back to John with some drafting lessons.
Thanks, Amelia. I recognize that many of us in the webinar have either paid our dues or are still paying our dues by laboring over disclosure schedules in the middle of the night. So I'll apologize in advance for any unwanted flashbacks. This case, following the closing of an investment in a healthcare technology company called Rhythm Management, the investor Aldrich Capital and the founder of Rhythm Management, Rhonda Bray, got into a dispute that centered on an IP infringement claim brought against Rhythm Management by a third party, Merge Inc. Prior to the lawsuit, Merge had licensed software to some critical software to Rhythm Management, with which Rhythm Management subsequently replaced with an in-house solution that allegedly infringed the IP subject to the license. The infringement litigation was pending at the time of the investment and was disclosed in the disclosure schedules as an exception to the no litigation representation. The investment agreement also contained a representation that Rhythm Management either owned or had a valid license to the IP necessary to conduct its business. We'll call that the ownership rep. A representation that Rhythm Management's business did not infringe on any third-party IP rights. That's the non-infringement rep. And a representation that no party to any of Rhythm Management's material contracts was in default or subject to breach, the material contracts rep. One of the issues in the litigation between Aldrich and Bray is whether the infringement litigation was properly disclosed against the ownership rep and the material contracts rep in order to prevent inaccuracies in those representations. Under the purchase agreement, disclosures made with respect to one representation are deemed to modify that representation and each other representation to the extent the applicability of such disclosure is readily apparent on its face. This standard is very common. It's generally thought to be somewhat seller-friendly as it permits the incorporation of relevant information disclosed in one area of the disclosure schedules to apply to other sections of the disclosure schedules without repetition or the need to explicitly cross-reference disclosures. So, how was the infringement litigation handled in the disclosure schedules here? As I mentioned before, it was specifically included as an exception to the no litigation rep. The disclosure made under the no litigation rep was also explicitly cross-referenced in the disclosure schedules for the no infringement rep. The schedule for the ownership rep was marked none, and no disclosure of the litigation, cross-reference or otherwise, was included in the schedule for the material contracts rep. In analyzing whether in analyzing whether or not application of the disclosure of the infringement limitation was readily apparent to the ownership rep and the material contracts rep, the court ruled no. In a letter opinion, the court determined that a reasonable interpretation of none in the schedule corresponding to the ownership rep was that no disclosure applied to that section, even if it was readily apparent that other disclosures included in the schedule could apply. The court also determined that it was not readily apparent that disclosure of the litigation applied to the material contracts rep, in part because the material contracts rep included explicit cross-references to other disclosures throughout the schedules. For both the ownership rep and the material contracts rep, the court also noted that the specific cross-reference to the infringement litigation included in the schedule to the non-infringement rep contributed to its conclusion that it was not readily apparent that disclosures of the litigation included elsewhere in the schedules applied to the ownership rep and the material contracts rep. So, in terms of drafting tips, well, there's always the evergreen advice that applies to all M&A drafting tasks. Be thoughtful and careful. Acknowledging the limited helpfulness of that advice, I'll offer something a little bit more concrete. Use none with caution. By including it in the schedules, you may be blocking any implicit cross-references that would otherwise apply. Great.
Some quick alt entity cases. I think we only have a couple of minutes, so I'm going to skip through the first one. If you are a fan of the artist known as Prince, or if you draft a lot of LLC agreements, I would suggest that it is actually not a long read, but a good one. I'm going to skip forward to Campus I Management Holdings versus DiDonato. In this one, we have an optometrist. He sold his practice to a PE firm. They restructured the practice. He ended up being the manager of a subsidiary. The PE firm decided they didn't like him. They tried to remove him through doing an amendment, but unfortunately they didn't get the appropriate vote to do so. They went back to the drawing table and realized that they did have the vote to do a merger. So what they did is they merged that subsidiary into a newly formed LLC agreement, and pursuant to the merger, they adopted a new LLC agreement, which changed the management structure. So DiDonato complains and the court holds, nope, it was all good. The merger was validly adopted, and pursuant to our LLC Act, you can adopt an amendment to an LLC agreement in a merger. So the key takeaway here, watch out for mergers. They are one way to get around amendment votes in an LLC agreement. So make sure that you draft in protective provisions for mergers and other reorganizations. I don't think we have time for our quick hitters. The basic gist of mine was that you have to be in good standing in Delaware before you do anything. You can't sign documents, you can't enter into litigation, so make sure you pay your franchise taxes. I know, Brian, do you want to do yours quickly?
Sure, yeah. Before we close our final case for today, I'll leave you to read, but suffice it to say, if you want to know who counts as an officer for purposes of your corporation's indemnification and advancement provisions, take a careful look at your bylaws and take a careful look at the Gilbert versus Unisys Corp case. You might be picking up more people than you think. So folks, that's all the time we have for you today. On behalf of Amelia and John, we thank you for your time and look forward to seeing you at the next M&A update.